I think we've had a number of situations in which the more conservative members of the court have been the First Amendment defenders, and the more liberal ones have been the ones opting in favor of more regulation by the government, even if there's some payment to be made in loss of speech. So I think I think I was prescient. No, I really do believe that that has been the direction for a few reasons, but not least that the cases that the court has had have often been ones in which conservatives happen to have an attachment to the First Amendment and liberals happen not to. Unfortunately, there aren't many people, in my view, who care enough about the First Amendment, whatever the issue is. I don't mean the First Amendment has to win all the time, but it is distressingly predictable that in certain types of areas, liberals alone care about the First Amendment. Sexually oriented speech, for example, the equivalent of book burnings, Mayor Giuliani's misbehavior with the Brooklyn Museum. And there are other ones in which conservatives are eloquent defenders of the First Amendment. And I mentioned a few in my article, and there have been more cases since then in the areas of abortion protests, for example. Very recently, of course, in the area of campaign finance legislation, where the 5-4 vote on the Supreme Court had the 5 members of the court who were basically sustaining the McCain-Feingold law, essentially treating the problem as a serious and important regulatory issue, but not a big First Amendment issue. And the dissenting justices, the more conservative members in the main, treating it as essentially a constitutional issue, one relating to the core of the First Amendment. And that was precisely what troubled me 6 years ago, and it troubles me even more now.
You say the more conservative members treating it as a constitutional issue. Why do you not give that to the more liberal members of the court who in the recent 5-4 decision did uphold campaign finance?
Basically because the more liberal members essentially treated the problem as a problem of fixing an electoral problem. That is to say, there was a problem, too much money, too much potential for corruption, too much suspicion of corruption, too much possibility of corruption. And so the next issue was essentially, well, surely Congress can play a major role in solving that. And then the question left was, well, is this the sort of thing, is this in the realm of what Congress can do? And the answer was a sort of, why not? It's within the realm. Whereas what I call the more conservative members of the court was saying, we start with speech. There is speech here, hardcore First Amendment speech occurring around election time. And the government, the Congress, the bill signed by the president is taking action which will have significant impact on that speech. Can we possibly permit that? What sort of showing would we need to permit that sort of direct impact on speech? And in my view, again, this is an oversimplification, but the more liberal members of the court didn't really take the speech issues terribly seriously.
I've always been puzzled why, when you say constitutional issue, you don't include that part of the Constitution, its preamble, for instance, that made important reference to the general welfare. Isn't that as much a constitutional issue as what we find further down in the document?
No, we had an amendment. We had the Bill of Rights as amendments to avoid simply relying on the text of the Constitution as it had been written. If mere reference to general welfare could carry the day, it would carry it all the time. I mean, Congress rarely acts in a sort of lunatic way. There's always some basis, some potential justification for what it does. And taking Congress at its best, it's because Congress thinks it's doing the right thing being to serve the public, to serve the general welfare. But that would leave no protection at all for interests as important as free speech interests. Because for one thing, they sometimes conflict with what the Congress, at least, thinks the general welfare is. And for another, even if they don't conflict, Congress is not the body that routinely spends much time factoring in constitutional norms unless it absolutely has to. Now, there's another part, Dick, to what you're asking me, and you and I, in a way, have talked about it in the past, and I've been thinking about it a lot recently, and that is the issue of whether you could say, as Justice Breyer has, both sides have the First Amendment. It's not just the First Amendment that I'm talking to you about. Justice Breyer and other people, very serious scholars, are of the view that the way one should view a lot of issues is to say the purpose of the First Amendment is to establish a democratic society, an egalitarian society. That's all First Amendment too, they say. I'm sorry if this is a monologue, but I say to myself when they say that, you're missing the point of it. One of the effects of the First Amendment is to lead us to a more democratic society. But the core of the First Amendment is a protection against the government getting involved with respect to speech issues. And literally, who can say what can be said, when it can be said, things like that.
Well, you were kind enough, good enough, to refer me to Justice Breyer's NYU speech.
Yes.
And I read it last night.
I bet you agreed with it.
You bet right. You bet right. You have no room for that, Floyd. So many times I've said here, if only you, my dear friend, would take that brilliant mind and find some way of finding what Congress has so frequently said is in the general welfare as not contradicting the First Amendment, not contradicting the Bill of Rights.
Yeah.
I'm sure you could, and in a sense, Justice Breyer has.
Sure, there are. I don't think Justice Breyer has.
You don't?
I don't. I think it's one thing for me to say to you, say in the campaign finance area, well, yeah, I think it would be constitutional to have a system like the New York City system, where if somebody spends money, the government advances certain amounts of money to the other side, so we have a lot of speech on both sides. That doesn't raise any First Amendment issues to me. But what Justice Breyer is really saying, as I suggested earlier, is that the First Amendment should properly be viewed not as a negative limitation on the government, but as a binding legal articulation of a commitment to a democratic society, and therefore that anything which will lead, this is me, not him now, anything which will lead to a more democratic society is therefore First Amendment protected. That to me is what a different justice, Justice Potter Stewart, once said was pursuing the values of the First Amendment at the expense of the First Amendment itself.
And you can't do that.
I
You
can't
don't
do
want to
that.
do
I don't
that.
want to do that. I think the court occasionally does it wrongly. See, from my perspective, just sort of opening it up and saying, gee, why can't Congress do things in the general welfare?
Mm-hmm.
Or, as Justice Breyer would say, gee, why can't Congress take steps which are for the purpose of the First Amendment-like purpose of making us a more democratic, egalitarian state? And I say to myself, I don't even want to start down the road. I don't even want to let Congress and the courts near the business of saying, you know, it's so important that this be done or that be done, that even if we do restrict speech, it's for a good cause.
Well, Breyer would say it is for its own sake.
He would say it.
Yeah.
He would say it. But I think that just opens it up to a series of ad hoc judgments by Congress and by the court, which throw out what to me is the core of the First Amendment. For example, as I read the recent opinion of the court, which my side lost in the campaign finance case, one would barely know that speech was involved at all. You would know that an election was involved. You would know money was involved. You would know that the misuse of money in the past, or the threat of misuse of money to get favors, or at least the impression of favors, was involved. But you wouldn't have any sense that what was happening was that a law was being passed saying that neither IBM nor the ACLU nor the AFL could put an ad on within 60 days of a federal election which mentioned the name of the President of the United States. That's the law that's now been held to be constitutional. Yeah.
If wishes.
If wishes.
Right.
If wishes.
Floyd, the notion that the First Amendment is designed to lead to protect, to give sustenance to a concept of a good society. I think that ultimately is what those of us who reject your absolutism say, that indeed there's a purpose to the First Amendment. It is secondary. It is a device. It is a means. That free speech, which you protect so wonderfully well, is a means of getting somewhere. And when we are at that point, you say no, because a real reading of the First Amendment says no law. Congress shall make no law.
I mean, it's true that I take a sort of an orthodox reading.
Oh, absolutist.
Absolutist, I think not. But I wrote an introduction to a book a few years ago. The book was called Political Censorship. It was a collection of New York Times articles throughout the 20th century about censorship throughout the world. 536 pages, filled with newspaper articles about censorship. And you know the justifications that they always used for censorship?
The
was the general welfare. And the justifications was, it's really good for speech. We'll have more speech. We'll have to decide, of course, the governments have always said, and we'll decide it. We'll take account of things like honor and national defense and secrecy and a whole lot of different things. Of course we'll take account of those things. But trust us, because at the end of the day, it's all for the general welfare. And indeed, they often say, it's really good for speech itself. And my reaction is, that's the Orwellian nightmare that we want to prevent. We want to avoid having congressmen pass laws those people saying you can't say that, because we think the effect of your saying that is really more harmful than beneficial. To me, that's no First Amendment at all.
Damn it, Floyd is right. The only way to protect that key factor in our lives of free speech is to protect it no matter what.